Hello, this is Matt on the Moon Lambo channel. Everyone enjoys a good smackdown, and that's what the content of this particular hot jam is all about. Here's the headline from you today. Ripple Chief Legal Officer and A16Z General Counsel clash in epic dispute. So this is Ripple's Chief Legal Officer, Stuart Alderati, he's on your screen right there, and A16Z, that's Andreessen Horowitz, venture capital firm, and may sound very familiar with you since you're in the XRP community, because they're the ones associated with Perkins Coie and the whole ETHgate situation. I don't need to get into that in this video, other than to say I've never seen a comment from a single individual working at Andreessen Horowitz that has had a single positive thing to say about Ripple or XRP. Not a single one. And so they're referencing Andreessen Horowitz is a general counsel, so also their top in-house lawyer, and they're clashing in a dispute having to do with what was at the center of the SEC v. Ripple case. And this is just an absolute, complete and utter smackdown, to the degree that the general counsel in question, Andreessen Horowitz, he never even responded. He just took his ball and went home, as he should do. And this is after Stuart Alderati responded to him. And also Attorney John Deaton, he's just silent on this because he's just wrong on the facts. It's just, and as you'll see as Attorney Stuart Alderati at Ripple stated, something to the effect of, yeah, it looks like you're just trying to rewrite history. I'll get you the exact words. But before going further, I would like to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And I'll tell you, it sure is interesting with so many people having gotten the outcome of this case so incredibly wrong. So many attorneys that, no, of course, this is going to be a slam dunk for the SEC. Ripple's in trouble, XRP's in security, whatever. There's all sorts of perspectives out there from all sorts of attorneys, and all of these ones, the attorneys that were on the wrong side of history here, they just, what I've noticed in the last few weeks since this positive ruling for XRP and for Ripple, is that they just don't want to give up. They don't want to say, yeah, wow, I was wrong. I should learn from this. Nothing of the sort. In fact, if anything, they just keep pushing back, and a lot of them insist that it's such a bad ruling that it's going to get overturned, this or that. And in this case, this particular attorney at Andreessen Horowitz is just saying crap that outright isn't true. And just as a minimal amount of table setting, so you can get a little taste of what this guy has put out in the past, I came up with this article from the Crypto Basic from November 9th of last year. It's titled, Deaton Slams A16Z General Counsel for Wrongly Asserting Ripple Should Be Decentralized. And I don't need to read the article, I'll just pull up the tweet that is shared on your screen here. And so the individual in question is Miles Jennings. He's the one that works at Andreessen Horowitz, the top in-house lawyer. And he wrote here, I don't need to read the whole screen, but you can see here he wrote, Ripple, not decentralized. And it's one of those, like, how is it that you are at the top of the food chain at this major VC firm, Andreessen Horowitz, and you're just decrying that Ripple is not decentralized? Because Ripple is a company. What the hell is a decentralized company? I've not seen one. Have you seen one? I've not seen one. And if he actually meant XRP, that's even worse, because XRP clearly is decentralized. And so Attorney Deaton retweeted that November 8th last year, and he wrote, should someone inform the general counsel of Andreessen Horowitz that Ripple and Library are companies with a CEO and a board of directors, and thus, by definition, are centralized entities? But then again, he may have learned about sufficient decentralization from his partner, Bill Hinman. And again, I don't want to go too, of course, into the whole ETHgate thing. You guys are well versed on that, I know. But yeah, it's just, again, somebody from Andreessen Horowitz saying crap like this. Yeah, that tracks. That tracks. That definitely tracks. And this is the individual in question on the Andreessen Horowitz website. This is Miles Jennings right here. And he so badly wanted to be right. He so wanted Ripple to go down in flames and XRP to be a security. You can just tell from the vibes that he puts out and the stuff that he's written. And he, by the way, he is one of the attorneys that prior to the ruling from Judge Torres thought that the SEC was going to have a slam dunk win, and nope. The SEC lost on the only real part of the case that matters. The idea that XRP is not a security And the SEC said there was. SEC lost. And so here's a tweet the other day from Stuart Alderati, and he wrote the following. To those saying the SEC doesn't think a token itself is a security, this is false. See the SEC's own words in the complaint against us, which the judge ultimately rejected. And here's the snippet that Stuart Alderati shared. It reads as follows. At all relevant times during the offering, XRP was an investment contract and therefore a security, subject to the registration requirements of the federal securities laws. And so there, clear as day, that's the SEC outright stating XRP is a security. It's on your screen. This is not complex. I know most of you out there are like me. You're not lawyers. I just play one on YouTube, right? We're not lawyers here, most of us. But we can understand that because we have more than half a brain, right? It doesn't take that much. Probably even with less than half a brain, I think I could probably still comprehend that, right? But then you have Miles Jennings. He jumps in here, and he responded. What a quip he's got here. He said, it literally says during the offering. So yes, in all sales, they were saying it was an investment contract. So he thinks he's got us here. So this is Miles Jennings, and saying he's basically arguing that the SEC is saying XRP was part of an illegal securities offering during the offering. That's the quote, during the offering, but disputes the idea that the SEC was arguing that XRP itself was, is, and will always be a security. So he's outright refuting the embodiment theory in which the SEC claims that XRP, the token itself, embodies the efforts of Ripple and is therefore always an illegal security. So that's what he's saying by that. Complete and utter bogus nonsense. He was already wrong about the SEC winning. That didn't happen. He's already wrong there. And now he's rewriting history, as Stuart Alderati ends up pointing out. So Stuart Alderati did respond. He wrote, the offering equals the 7-year time period covered by the complaint, 2013 through 2020. The SEC, touting their nonsensical embodiment theory, told the court that the XRP itself represents the investment contract in filings. And he's spot on. That is what happened. So yes, for the time period 2013 through 2020, you could say that, you could argue that's unique to those transactions, but what else was stated? What else was stated was the embodiment theory, the BS nonsense, which Judge Torres just ripped to shreds, absolutely tore to shreds that concept. Because the court said that the XRP itself represented the investment contract. So if the investment contract in the case of Ripple, even if you wanted to argue, okay, so fine, it's 2013 to 2020. But it's still XRP that represents, XRP itself that represents the investment contract. And Miles Jennings, how could he not know better than this? How the hell could he not know better than this? So Stuart Alderati in a separate tweet then wrote, not surprising you're trying to rewrite history given you wrongly predicted Ripple would lose. And I need to heart that one too, actually. There we go. In fact, let's retweet that out. For posterity. For posterity, Stuart Alderati. These people, they grind my gears, son. They grind my gears. So thankfully the SmackDown's not done. Let's get to what Attorney John Deaton had to say on this. He also wrote to Miles Jennings and said, not sure why there's a debate about syntax. My entire involvement in this case was because the SEC essentially claimed XRP itself was a security. When I filed the motion to intervene, Ripple told the court that if the SEC would stipulate XRP was not a security per se, and the claims were only limited to Ripple's sales of XRP, then Deaton and his XRP holders would have little to say, and should not have amicus status with participatory rights. But if the SEC wouldn't so stipulate, XRP holders should be allowed as amicus with participatory rights. The SEC responded on page 24 of its opposition that XRP, even in the secondary market, embodied and represented the security. That's the functional equivalent of saying XRP itself is a security. Yep, exactly. Attorney Deaton's correct, and it's the same meaning. And then he wrote, in fact, I had an entire heading in my brief titled, The SEC Claims XRP Itself is a Security. And then he writes, I know I don't write like a career securities lawyer, but here's what I wrote. And I do want to share this with you in all of its glory. And so this is what Deaton wrote to Judge Torres. And Honestly, this is one of my favorite things that I've ever seen written by Attorney Deaton in this case to the judge. And it is absolutely glorious here. And so we shared the relevant portions in two separate screen grabs, which read as follows. And just to cement that this Miles Jennings guy, another Andreessen Horowitz guy, absolutely incorrect. It's a fantastic, delightful, and tasty smackdown. So here's how it reads. From the filing of the original complaint, and this is, again, under the heading, the SEC claims XRP itself as a security. From the filing of the original complaint to the motion for summary judgment, and filings in between, the SEC has consistently argued XRP itself is a security. Although the SEC admits that, quote, Howey requires courts to look at the economic reality of a transaction, end quote, and that the SEC must prove specific transactions offered by Ripple violated Section 5 of the Securities Act, the SEC is not pursuing specific transactions. Instead, it is asking the court to rule that every XRP transaction is either a Section 5 violation or qualifies for an exemption under Section 4. The SEC asks this court to validate its shorthand and analytically lazy contention that Ripple has engaged in the functional equivalent of a 9-year-long, ongoing, 24/7 initial coin offering, and that each and every sale of XRP from anywhere in the world, offered by anyone, including Amici, was, is, always has been, and always will be the offer and sale of a security. I absolutely love that line. That's my favorite. That is absolutely my favorite. And by the way, I'll mention here when he cited Section 5 and then Section 4, and he's talking, so Section 4 would be the exemption. But the thing about that Section 4 exemption, it only applies if the thing that you're talking about is a security. So you'd have to find that XRP is a security, and then you could have, in theory, exemptions under Section 4. So it still doesn't work. And this is the SEC. They were arguing that, like, what a joke. Anyway, the good news is Judge Torres obviously was able to easily see through this, right? She was able to, sniff out that there are a bunch of asshat pricks. I'm pretty sure she was able to easily do that, in fact. Anyway, and then this reads as follows, and this is a quote, so I believe this part here is from what the SEC wrote, because it says ECF, which is, I believe, electronic case file, and then it says, and this is in quotes, a purchase of XRP was an investment of money into a common enterprise with other XRP investors and with defendants, end quote. Yeah, so that's what the part of what the SEC asserted. And then there's another one here, quote, a purchase of XRP is an investment in a common enterprise with other XRP holders and with Ripple. And so note the word is there, which Attorney Deaton put in bold. He added that emphasis to make the point. Is and into the future. It is every single transaction illegal, no matter what happens with it, always. And then there was another one, also from the SEC. The XRP traded even in the secondary market today represents that investment contract. And then it says, the SEC's XRP theory is so far-fetched, it travels through space and time, I love this so much, into the future, capturing all possible future sales, even in faraway lands. And then here's another quote from the SEC. Quote, even if some country were to recognize XRP as fiat currency at some point in the future, that would result from defendants' significant entrepreneurial and managerial efforts to date, and likely in the future, on which public investors expecting profit relied when making an investment of money into defendants' common enterprise, end quote. So there you go. The SEC say, even if a country declares XRP as an officially recognized currency by that country, it's still because it's all the efforts of Ripple. So there you go. What? Oh, I love this. And we can laugh about it now because it's over, but anyway, Deaton continues. The scope of the SEC's Howey argument has become so stretched that it is truly indefinable in space or in time. As discussed, infra at, and so he's citing whatever the reference point is here. The SEC asked this court to assume private statements made by Ripple employees many years ago to a handful of individuals equals evidence that Ripple offered XRP to the world. The SEC is not allowed to shortcut the Howey analysis by alleging each and every sale of XRP from the beginning of time until the end of the world. I love this so much. Love it so much. Meets all three Howey prongs, and therefore doesn't have to offer specific transactional evidence. The Howey test must be applied to each transaction and examined as of the time that the transaction took place. Instead, the SEC argues, quote, the XRP traded even in the secondary market is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract, end quote. There you go. That's the embodiment theory. That is the functional equivalent of saying XRP is a security. They didn't want to come out and say it like that, but Judge Torres isn't stupid. She didn't fall for the BS. And then Deaton says, notably missing at the end of that sentence is a single cite to any precedent or authority supporting such an inimitable claim. Amici, and likely the SEC itself, have no idea what that sentence means under the law. The SEC's theory is the equivalent of arguing individual oranges were not only oranges, but also represented the investment contract with the W.J. Howey Company. The SEC's theory would be a bit amusing if innocent holders weren't being severely harmed. Spot on, Attorney Deaton, but now it is amusing because we're all good. I mean, yes, actually, I think it's okay to laugh at this point because at some point enough time has to have passed, but yes, I recognize that there are people that panic sold and this or that and were financially harmed, and I'm never going to make light of that. I understand how serious that is. And it caused all of us in the community, all of us XRP holders, an incredible amount of stress, and I get that. I understand. That was not a fun time period, especially after the news broke that XRP holders were under assault from the SEC because they sued Ripple. Because in the earliest of days, there was so much uncertainty, we didn't know what the legal implications were. And that's worse. So if we had an understanding, which we ultimately did get to, and then we could kind of chill out a little bit thinking, no, we're really on the right side of the law. But, in a vacuum where most of us not being lawyers, obviously, we're not certain. It's the not knowing that was so scary. That's what was the most terrifying part, I think, for pretty much any XRP holder at the time. But as we acquired information and became, as we became securities lawyers, right? As we became that over a span of years, became clear, and we're probably going to be in the good, and we are. We're absolutely good here. And then also Attorney Deaton citing here, big claim, the embodiment theory. Where's the citation? Where's the case law? Where's the precedent that would back this assertion? Well, it doesn't exist because the SEC pulled that embodiment theory BS nonsense right on from their rear side, and they were hoping they could just get away with it, but Judge Torres wasn't having it. So there you go, smackdown complete. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.